Hello, friends. Welcome to the international law series of policy-based Loksewa. On this episode, I'm presenting the Convention on the Rights of the Child directly from the website of the United Nations Human Rights Office of the High Commission. So let's begin. The Convention on the Rights of the Child, adopted on 20th November 1989 by the General Assembly Resolution 44/25, entered into force from 22nd September 1990 in accordance with Article 49, Preamble. The states parties to the present convention, considering that in accordance with the principles proclaimed in the Charter of the United Nations, recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world, bearing in mind that the peoples of the United Nations have in the Charter reaffirmed their faith in fundamental human rights and in the dignity and worth of human person, and have determined to promote social progress and better standards of life in larger freedom, recognizing that the UN has, in the Universal Declaration of Human Rights and in the International Covenants of Human Rights, proclaimed and agreed that everyone is entitled to all the rights and freedoms set forth therein without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status, recalling that in the Universal Declaration of Human Rights, the UN has proclaimed that childhood is entitled to special care and assistance, convinced that the family as the fundamental group of society and the natural environment for growth and well-being of all its members, and particularly children, should be afforded the necessary protection and assistance so that it can fully assume its responsibility within the community, recognizing that the child, for the full and harmonious development of his or her personality, should grow up in a family environment in an atmosphere of happiness, love, and understanding, considering that the child should be fully prepared to live an individual life in society and brought up in the spirit of the ideals proclaimed in the Charter of the UN, and in particular in the spirit of peace, dignity, and tolerance, freedom, equality, and solidarity, bearing in mind that the need to extend particular care to child has been stated in the Geneva Declaration of the Rights of the Child of 1924 and in the Declaration of the Rights of the Child adopted by the General Assembly on 20th November 1959, and are recognized in the Universal Declaration of Human Rights in the International Covenant on Civil and Political Rights, in particular in Articles 23 and 24, in the International Covenant on Economic, Social, and Cultural Rights, in particular in Article 10, and in the statutes and relevant instruments of specialized agencies and international organizations concerned with the welfare of children, bearing in mind that, as indicated in the Declaration of the Rights of the child, by reason of his physical and mental immaturity, needs special safeguards and care, including appropriate legal protection before as well as after birth, recalling the provisions of the Declaration on Social and Legal Principles relating to the protection and welfare of children, with a special reference to foster placement and adoption nationally and internationally, the UN Standard Minimum Rules for Administration of Juvenile Justice, the Beijing Rules, and the Declaration on the Protection of Women and Children in Emergency and Armed Conflict, recognizing that in all countries in the world there are children living in exceptionally difficult conditions, that such children need a special consideration, taking due account of the importance of the traditions and cultural values of each people for the protection and harmonious development of the child, recognizing the importance of international cooperation for improving the living conditions of the children in every country, in particular in the developing countries, have agreed as follows. Part 1st, Article 1. For the purposes of the present convention, a child means every human being below the age of 18 years, unless under the law applicable to the child majority is attained earlier. Article 2, Para 1st, states parties shall respect and ensure the rights set forth in the present convention to each child within their jurisdiction without discrimination of any kind, irrespective of the child's or his or her parents or legal guardians, race, color, sex, language, religion, political or other opinion, national, ethnic or social origin, property, disability, birth or other status. Para 2, states parties shall take all appropriate measures to ensure that the child is protected against all forms of discrimination or punishment on the basis of the status, activities, expressed opinions, or beliefs of the child's parents, legal guardians, or family members. Article 3. Para 1st, in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies. The best interests of the child shall be of primary consideration. Para 2. States parties undertake to ensure the child's such protection and care as is necessary for his or her well-being, taking into account the rights and duties of his or her parents, legal guardians, or other individuals legally responsible for him or her, and to this end shall take all appropriate legislative and administrative measures. Para third, states parties shall ensure that institutions, services, and facilities responsible for the care or protection of the children shall conform with the standards established by competent authorities, particularly in the areas of safety, health, in the number and suitability of their staff, as well as competent supervision. Article 4. States parties shall undertake all appropriate legislative, administrative, and other measures for the implementation of the rights recognized in the present convention. With regard to economic, social, and cultural rights, states parties shall undertake such measures to the maximum extent of their available resources and, where needed, within the framework of international cooperation. Article 5. State parties shall respect the responsibilities, rights, and duties of parents, or, where applicable, the members of the extended family or community as provided for by local custom, legal guardians, or other persons legally responsible for the child, to provide in a manner consistent with the evolving capacities of the child appropriate direction and guidance in the exercise by the child of the right recognized in the present convention. Article 6, para 1st. States parties recognize that every child has the inherent right to life. Para second, states parties shall ensure to the maximum extent possible the survival and development of the child. Article 7. Para first, the child shall be registered immediately after birth and shall have the right from the birth to name, the right to acquire a nationality, and, as far as possible, the right to know and be cared for by his or her parents. Para 2. States parties shall ensure the implementation of these rights in accordance with their national law and their obligations under the relevant international instruments in this field, in particular where the child would otherwise be stateless. Article 8, para 1st. States parties undertake to respect the right of the child to preserve his or her identity, including nationality, name, and family relations as recognized by law without unlawful interference. Para 2. While a child is illegally deprived of some or all of the elements of his or her identity, states parties shall provide appropriate assistance and protection with a view to re-establishing speedily his or her identity. Article 9, para 1st. States parties shall ensure that a child shall not be separated from his or her parents against their will, except when competent authorities subject to judicial review determine, in accordance with applicable law and procedures, that such separation is necessary for the best interests of the child. Such determination may be necessary in a particular case, such as one involving abuse or neglect of the child by the parents, or one where parents are living separately and a decision must be made as to the child's place of residence. Para 2. In any proceedings pursuant to paragraph 1st of this present article, all interested parties shall be given an opportunity to participate in the proceedings and make their views known. Para 3rd. Para 3rd. States parties shall respect the right of the child who is separated from one or both parents to maintain personal relations and direct contact with both parents on a regular basis, except if it is contrary to the child's best interests. Para 4. Where such separation results from any action initiated by a state party, such as the detention, imprisonment, exile, deportation, or death, including death arising from any cause while the person is in the custody of the state of one or both parents or of the child, the state party shall, upon request, provide the parents, the child, or, if appropriate, another member of the family with the essential information concerning the whereabouts of the absent members of the family, unless the provision of the information would be detrimental to the well-being of the child. States parties shall further ensure that the submission of such a request shall of itself entail no adverse consequences for the persons concerned. Article 10, para 1st. In accordance with the obligation of states parties under Article 9, paragraphs 1st, applications by a child or his or her parents to enter or leave a state party for the purpose of family reunification shall be dealt with by states parties in a positive, humane, and expeditious manner. States parties shall further ensure that the submission of such a request shall entail no adverse consequences for the applicants and for the members of their family. Para 2. A child whose parents reside in different states shall have the right to maintain on a regular basis privacy, save in exceptional circumstances, personal relations, and direct contacts with both parents. Towards that end, and in accordance with the obligation of states parties under Article 9, paragraph 1st, states parties shall respect the right of the child and his or her parents to leave any country, including their own, and to enter their own country. The right to leave any country shall be subject only to such restrictions as are prescribed by law and which are necessary to protect the national security, public order republic, public health and morals, or the rights and freedoms of others, and are consistent with the other rights recognized in the present convention. Article 11, Para first, states parties shall take measures to combat the illicit transfer and non-return of children abroad. Para second, to this end, states parties shall promote the conclusion of bilateral or multilateral agreements or accession to existing agreements. Article 12, Para first, states parties shall assure to the child who is capable of forming his or her own views the right to express those views freely in all matters affecting the child, the views of the child being given due weight in accordance with the age and maturity of the child. Para second, for this purpose, the child shall in particular be provided the opportunity to be heard in any judicial or an administrative proceedings affecting the child, either directly or through a representative or an appropriate body in a manner consistent with the procedural rules of national law. Article 13, Para first, the child shall have the right to freedom of expression. This right shall include freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers, either orally, in writing, or in print, in the form of art, or through any other media of the child's choice. Para second, the exercise of this right may be subject to certain restrictions, but these shall only be such as are provided by law and are necessary: A. For respect of the rights and reputations of others, or B. For protection of national security or of public order, or republic, or of public health or morals. Article 14, Para first, states parties shall respect the right of the child to freedom of thought, conscience, and religion. Para second, states parties shall respect the rights and duties of the parents and, when applicable, legal guardians to provide direction to the child in the exercise of his or her right in a manner consistent with the evolving capacities of the child. Para third, freedom to manifest one's religion or beliefs may be subject only to such limitations as are prescribed by law and are necessary to protect public safety, order, health or morals, or the fundamental rights and freedoms of others. Article 15, Para first, states parties recognize the rights of the child to freedom of association and to freedom of peaceful assembly. Para second, no restriction may be placed on the exercise of these rights over those imposed in conformity with the law and which are necessary in a democratic society in the interests of the national security or public safety, public order republic, the protection of public health or morals, or the protection of the rights and freedoms of others. Article 16, Para first, no child shall be subjected to arbitrary or unlawful interference with his or her privacy, family, home, or correspondence, nor to unlawful attacks on his or her honor and reputation. Para second, the child has the right to the protection of the law against such interference or attacks. Article 17, states parties recognize the important functions performed by the mass media and shall ensure that the child has access to information and material from a diversity of national and international sources, especially those aimed at the promotion of his or her social, spiritual, and moral well-being and physical and mental health. To this end, states parties shall: A. Encourage the mass media to disseminate information and material of social and cultural benefit to the child and in accordance with the spirit of Article 29. B. Encourage international cooperation in the production, exchange, and dissemination of such information and material from a diversity of cultural, national, and international sources. C. Encourage the production and dissemination of children's books. D. Encourage the mass media to have particular regard to the linguistic needs of the child who belongs to a minority group or who is indigenous. E. Encourage the development of appropriate guidelines for the protection of the child from information and material injurious to his or her well-being, bearing in mind the provisions of Article 13 and 18. Article 18, Para first, states parties shall use their best efforts to ensure recognition of the principle that both parents have common responsibilities for the upbringing and development of the child. Parents, or as the case may be, legal guardians, have the primary responsibility for the upbringing and development of the child. The best interests of the child will be their basic concern. Para 2. For the purpose of guaranteeing and promoting the rights set forth in the present convention, states parties shall render appropriate assistance to parents and legal guardians in the performance of their child rearing responsibilities, and shall ensure the development of institutions, facilities, and services for the care of children. Para third, states parties shall take all appropriate measures to ensure that children of working parents have the right to benefit from child care services and facilities for which they are eligible. Article 19, para 1st, states parties shall take all appropriate legislative, administrative, social, and educational measures to protect the child from all forms of physical or mental violence, injury or abuse, neglect or negligent treatment, maltreatment, or exploitation, including sexual abuse, while the care of parents, legal guardians, or any other person who has the care of the child. Para second, such protective measures should, as appropriate, include effective procedures for the establishment of social programs to provide necessary support for the child and for those who have the care of the child, as well as for other forms of prevention and for identification, reporting, referral, investigation, treatment, and follow-up of instances of child maltreatment described heretofore, and as appropriate for judicial involvement. Article 20, para 1st, a child temporarily or permanently deprived of his or her family environment, or in whose own best interest cannot be allowed to remain in that environment, shall be entitled to special protection and assistance provided by the state. Para second, states parties shall, in accordance with their national laws, ensure alternative care for such a child. Para third, such care could include inter alia, foster placement, kafala of Islamic law, adoption, or if necessary, placement in suitable institutions for the care of children. When considering solutions, due regard shall be paid to the desirability of continuity in a child's upbringing and to the child's ethnic, religious, cultural, and linguistic background. Article 21. States parties that recognize and/or permit the system of adoption shall ensure that the best interests of the child shall be the paramount consideration, and they shall ensure that the adoption of a child is authorized only by competent authorities who determine, in accordance with the applicable law and procedures and on the basis of pertinent and reliable information, that the adoption is permissible in view of the child's status concerning parents, relatives, and legal guardians, and that if required, the persons concerned have given their informed consent to the adoption on the basis of such counseling as may be necessary. B. Recognize that inter-country adoption may be considered as an alternative means of child's care if the child cannot be placed in a foster or an adoptive family, or cannot in any suitable manner be cared for in the child's country of origin. C. Ensure that the child concerned by inter-country adoption enjoys safeguards and standards equivalent to those existing in case of national adoption. D. Take all appropriate measures to ensure that in inter-country adoption, the placement does not result in improper financial gain for those involved in it. E. Promote where appropriate the objectives of the present article by concluding bilateral or multilateral arrangements or agreements, and endeavor within this framework to ensure that the placement of the child in another country is carried out by competent authorities or organs. Article 22, para 1st, states parties shall take appropriate measures to ensure that a child who is seeking refugee status, or who is considered a refugee in accordance with applicable international or domestic law and produces procedure, shall, whether unaccompanied or accompanied by his or her parents or by any other person, receive appropriate protection and humanitarian assistance in the enjoyment of applicable rights set forth in the present convention and in other international human rights or humanitarian instruments to which the said states are parties. Para second, for this purpose, states parties shall provide, as they consider appropriate, cooperation in any efforts by the UN and other competent intergovernmental organizations or non-governmental organizations cooperating with the UN to protect and assist such a child, and to trace the parents or other members of the family of any refugee child in order to obtain information necessary for reunification with his or her family. In cases where no parents or other members of the family can be found, the child shall be accorded the same protection as any other child permanently or temporarily deprived of his or her family environment for any reasons, as set forth in the present convention. Article 23, para 1st, states parties recognize that a mentally or physically disabled child should enjoy a full and decent life in conditions which ensure dignity, promote self-reliance, and facilitate the child's active participation in the community. Para second, states parties recognize the right of the disabled child to special care and shall encourage and ensure the extension subject to available resources to the eligible child and those responsible for his or her care of assistance for which application is made and which is appropriate to the child's condition and to circumstances of the parents and others caring for the child. Para third, recognizing the special needs of a disabled child, assistance extended in accordance with paragraph 2 of the present article shall be provided free of charge whenever possible, taking into account the financial resources of the parents or other caring for the child, and shall be designed to ensure that the disabled child has effective access to and receives education, training, healthcare services, rehabilitation services, preparation for employment, and recreation opportunities in a manner conducive to the child's achieving the fullest possible social integration and individual development, including his or her cultural and spiritual development. Para 4. States parties shall promote, in the spirit of international cooperation, the exchange of appropriate information in the field of preventive health care and of medical, psychological, and functional treatment of disabled children, including dissemination of and access to information concerning methods of rehabilitation, education, and vocational services, with the aim of enabling states parties to improve their capabilities and skills and to widen their experience in these areas. In this regard, particular account shall be taken of the needs of the developing countries. Article 24, para first, states parties recognize the right of the child to the enjoyment of the highest attainable standard of health and to facilities for the treatment of illness and rehabilitation of health. States parties shall strive to ensure that no child is deprived of his or her right of access to such healthcare services. Para second, states parties shall pursue full implementation of this right and in particular shall take appropriate measures: A. To diminish infant and child mortality; B. To ensure the provision of necessary medical assistance and healthcare to all children with emphasis on the development of primary healthcare; C. To combat disease and malnutrition, including within the framework of primary health care through inter alia, the application of readily available technology, and through the provision of adequate nutritious foods and clean drinking water, taking into consideration the dangers and risks of environmental pollution. D. To ensure appropriate prenatal and postnatal health care for mothers. E. To ensure that all segments of society, in particular parents and children, are informed, have access to education, and are supported in the use of basic knowledge of child health and nutrition, the advantages of breastfeeding, hygiene and environmental situation, and the prevention of accidents. F. To develop preventive healthcare guidance for parents and family planning, education, and services. Para third, states parties shall take all effective and appropriate measures with a view to abolishing traditional practices prejudicial to the health of children. Para fourth, states parties undertake to promote and encourage international cooperation with a view to achieving progressively the full realization of the right recognized in the present article. In this regard, particular account shall be taken of the needs of developing countries. Article 25. Article 25 states parties recognize the right of a child who has been placed by the competent authorities for the purposes of care, protection, or treatment of his or her physical or mental health to a periodic review of the treatment provided to the child and all other circumstances relevant to his or her placement. Article 26, para first, states parties shall recognize for every child the right to benefit from social security, including social insurance, and shall take the necessary measures to achieve the full realization of this right in accordance with their national law. Para second, the benefits would, where appropriate, be granted taking into account the resources and the circumstances of the child and persons having responsibility for the maintenance of the child, as well as any other considerations relevant to an application for benefits made by or on behalf of the child. Article 27, para first, states parties recognize the right of every child to a standard of living adequate for the child's physical, mental, spiritual, moral, and social development. Para 2, the parents or others responsible for the child have the primary responsibility to secure, within their abilities and financial capacities, the conditions of living necessary for the child's development. Para third, states parties, in accordance with the national conditions and within their means, shall take appropriate measures to assist parents and others responsible for the child to implement the right and shall, in case of need, provide material assistance and support programs, particularly with regard to nutrition, clothing, and housing. Para 4. States parties shall take all appropriate measures to secure the recovery of maintenance for the child from the parents or other persons having financial responsibility for the child, both within the state party or and from abroad, in particular where the person having financial responsibility for the child lives in a state different from that of the child. States parties shall promote the accession to international agreement or the conclusion of such agreements, as well as the making of other appropriate arrangements. Article 28, para 1st. States parties recognize the right of the child to education, and with a view to achieving this right progressively and on the basis of equal opportunity, they shall in particular a. Make primary education compulsory and available free to all. B. Encourage the development of different forms of secondary education, including general and vocational education, make them available and accessible to every child, and take appropriate measures such as the introduction of free education and offering financial assistance in case of need. C. Make higher education accessible to all on the basis of capacity by every appropriate means. D. Make educational and vocational information and guidance available and accessible to all children. E. Take measures to encourage regular attendance at schools and the reduction of dropout rates. Para 2. States parties shall take all appropriate measures to ensure that school discipline is administered in a manner consistent with the child's human dignity and in conformity with the present convention. Para 3. States parties shall promote and encourage international cooperation in matters relating to education, in particular with a view to contributing to the elimination of ignorance and illiteracy throughout the world and facilitating access to scientific and technical knowledge and modern teaching methods. In this regard, particular account shall be taken of the needs of developing countries. Article 29, para 1st. States parties agree that the education of the child shall be directed to a. The development of the child's personality, talents, and mental and physical abilities to their fullest potential. B. The development of the respect for human rights and fundamental freedoms and for the principles enshrined in the Charter of the UN. C. The development of respect for the child's parents, his or her own cultural identity, language, and values, for the national values of the country in which the child is living, the country from which he or she may originate, and for civilizations different from his or her own. D. The preparation of the child for responsible life in a free society in the spirit of understanding, peace, tolerance, equality of sexes, and friendship among all peoples, ethnic, national, and religious groups and persons of indigenous origin. E. The development of respect for the natural environment. Para 2. No part of the present article or Article 28 shall be construed as so as to interfere with the liberty of individuals and bodies to establish and direct educational institutions, subject always to the observance of the principles set forth in paragraph 1st of the present article, and to the requirements that the education given in such institutions shall conform to such minimum standards as may be laid down by the state. Article 30. In those states in which ethnic, religious, or linguistic minorities or persons of indigenous origin exist, a child belonging to such a minority or who is indigenous shall not be denied the right in community with other members of his or her group to enjoy his or her own culture, to profess and practice his or her own religion, or to use his or her own language. Article 31, para 1st. States parties recognize the right of the child to rest and leisure, to engage in play and recreational activities appropriate to the age of the child, and to participate freely in cultural life and the arts. Para 2nd. States parties shall respect and promote the right of the child to participate fully in cultural and artistic life, and shall encourage the provision of appropriate and equal opportunities for cultural, artistic, recreational, and leisure activity. Article 32, para 1st. States parties recognize the right of the child to be protected from economic exploitation and from performing any work that is likely to be hazardous or to interfere with the child's education or to be harmful to the child's health or physical, mental, spiritual, moral, or social development. Para 2. States parties shall take legislative, administrative, social, and educational measures to ensure the implementation of the present article. To this end, and having regard to the relevant provisions of other international instruments, states parties shall in particular a. Provide for a minimum age or minimum ages for admission to employment. B. Provide for appropriate regulation of the hours and conditions of employment. C. Provide for appropriate penalties or other sanctions to ensure the effective enforcement of the present article. Article 33. The states parties shall take all appropriate measures, including legislative, administrative, social, educational measures to protect children from the illicit use of narcotic drugs and psychotropic substances as defined in the relevant international treaties, and to prevent the use of children in the illicit production and trafficking of such substances. Article 34. States parties undertake to protect the child from all forms of sexual exploitation and sexual abuse. For these purposes, states parties shall in particular take all appropriate national, bilateral, and multilateral measures to prevent the inducement or coercion of a child to engage in any unlawful sexual activity, b. the exploitative use of children in prostitution or other unlawful sexual practices, c. the exploitative use of children in pornographic performances and materials. Article 35. States parties shall take all appropriate national, bilateral, multilateral measures to prevent the abduction of, the sale of, or traffic in children for any purpose or in any form. Article 36. States parties shall protect the child against all other forms of exploitation prejudicial to any aspects of the child's welfare. Article 37. States parties shall ensure that a. No child shall be subjected to torture or other cruel, inhuman, or degrading treatment or punishment. Neither capital punishment nor life imprisonment without possibility of release shall be imposed for offences committed by persons below 18 years of age. b. No child shall be deprived of his or her liberty unlawfully or arbitrarily. The arrest, detention, or imprisonment of a child shall be in conformity with the law and shall be used only as a measure of last resort and for the shortest appropriate period of time. c. Every child deprived of liberty shall be treated with humanity and respect for the inherent dignity of the human person, and in a manner which takes into account the needs of persons of his or her age. In particular, every child deprived of liberty shall be separated from adults unless it is considered in the child's best interest not to do so, and shall have the right to maintain contact with his or her family through correspondence and visits, and save in exceptional circumstances. D. Every child deprived of his or her liberty shall have the right to prompt access to legal and other appropriate assistance, as well as the right to challenge the legality of the deprivation of his or her liberty before a court or other competent, independent, and impartial authority, and to a prompt decision on any such action. Article 38, para first. Parties undertake to respect and to ensure respect for rules of international humanitarian law applicable to them in armed conflicts which are relevant to the child. Para B. Para 2. States parties shall take all feasible measures to ensure that persons who have not attained the age of 15 years do not take a direct part in hostilities. Para 3. States parties shall refrain from recruiting any person who has not attained the age of 15 years into their armed forces. In recruiting among those persons who have attained the age of 15 years but who have not attained the age of 18 years, states parties shall endeavor to give priority to those who are oldest. Para 4. In accordance with their obligations under international humanitarian law to protect the civilian population in armed conflicts, states parties shall take all feasible measures to ensure protection and care of children who are affected by an armed conflict. Article 39. State parties shall take all appropriate measures to promote physical and psychological recovery and social reintegration of a child victim of any form of neglect, exploitation or abuse, torture or any other form of cruel, inhuman or degrading treatment or punishment or armed conflicts. Such recovery and reintegration shall take place in an environment which fosters the health, self-respect and dignity of the child. Article 40, para first. States parties recognize the right of every child alleged as accused of or recognized as having infringed the penal law to be treated in a manner consistent with the promotion of the child's sense of dignity and worth, which reinforces the child's respect for the human rights and fundamental freedoms of others, and which takes into account the child's age and the desirability of promoting the child's reintegration and the child's assuming a constructive role in society. Para 2. To this end, and having regard to the relevant provisions of international instruments, states parties shall in particular ensure that a. No child shall be alleged as be accused of or recognized as having infringed the penal law by reason of acts or omissions that were not prohibited by national or international law at the time they were committed. B. Every child alleged as or accused of having infringed the penal law has at least the following guarantees. I. To be presumed innocent until proven guilty according to law. II. To be informed promptly and directly of the charges against him or her, and if appropriate, through his or her parents or legal guardians, and to have legal or other appropriate assistance in the preparation and presentation of his or her defense. III. To have the matter determined without delay by the competent, independent, and impartial authority or judicial body in a fair hearing according to law, in the presence of legal or other appropriate assistance, and unless it is considered not to be in the best interest of the child, in particular taking into account his or her age or situation, his or her parents or legal guardians. IV. Not to be compelled to give testimony or to confess guilt, to examine or have examined adverse witnesses, and to obtain the participation and examination of witnesses on his or her behalf under conditions of equality. B. If considered to have infringed the penal law, to have this decision and any measures imposed in consequence thereof reviewed by a higher competent, independent, and impartial authority or judicial body according to law. VI. To have the free assistance of an interpreter if the child cannot understand or speak the language used. BII. To have his or her privacy fully respected at all stages of the proceedings. Para third. States parties shall seek to promote the establishment of laws and procedures, authorities and institutions specifically applicable to children alleged as accused of or recognized as having infringed the penal law, and in particular, A. The establishment of a minimum age below which children shall be presumed not to have the capacity to infringe the penal law. B. Whenever appropriate and desirable, measures for dealing with such children without resorting to judicial proceedings, providing that human rights and legal safeguards are fully respected. 4. Para 4. A variety of dispositions such as care, guidance and supervision, orders, counseling, provision, foster care, education and vocational training programs, and other alternatives to institutional care shall be available to ensure that children are dealt with in a manner appropriate to their well-being and proportionate both to their circumstances and the offense. Article 41. Nothing in the present convention shall affect any provisions which are more conducive to the realization of rights of the child and which may be contained in A. The law of a state party, or B. International law in force for that state. Part 2. Article 42. States parties undertake to make the principles and provisions of the convention widely known by appropriate and active means to adults and children alike. Article 43, para first, for the purpose of examining the progress made by states parties in achieving the realization of the obligations undertaken in the present convention, there shall be established a committee on the rights of the child which shall carry out the functions hereinafter provided. Para second, the committee shall consist of 18 experts of high moral standing and recognized competence in the fields covered by this convention. The members of the committee shall be elected by states parties from among their nationals and shall serve in their personal capacity, consideration being given to equitable geographical distribution as well as to the principal legal systems. Para third, the members of the committee shall be elected by secret ballot from a list of persons nominated by states parties. Each state party may nominate one person from among its own nationals. Para 4. The initial election to the committee shall be held no later than 6 months after the date of the entry into force of the present convention, and thereafter every second year, at least 4 months before the date of each election. The Secretary General of the UN shall address a letter to the states parties inviting them to submit their nominations within 2 months. The Secretary General shall subsequently prepare a list in alphabetical order of all persons thus nominated, indicating states parties which have nominated them, and shall submit it in the states parties to the present convention. Para 5. The elections shall be held at meetings of states parties convened by the Secretary General of the United Nations headquarters. At those meetings, for which two-thirds of the states parties shall constitute a quorum, the persons elected to the committee shall be those who obtain the largest number of votes and an absolute majority of the votes of the representatives of states parties present and voting. Para 6. The members of the committee shall be elected for a term of 4 years. They shall be eligible for re-election if renominated. The term of 5 of the members elected at the first election shall expire at the end of 2 years. Immediately after the first election, the names of these 5 members shall be chosen by lot by the chairman of the meeting. Para 7. If a member of the committee dies or resigns or declares that for any other cause he or she can no longer perform the duties of the committee, the state party which nominated the member shall appoint another expert from among its nationals to serve for the remainder of the term, subject to the approval of the committee. Para 8. The committee shall establish its own rules of procedure. Para 9. The committee shall elect its officers for a period of 2 years. Para 10. The meetings of the committee shall normally be held at the United Nations headquarters or at any other convenient place as determined by the committee. The committee shall normally meet annually. The duration of the meetings of the committee shall be determined and reviewed if necessary by a meeting of the states parties to the present convention, subject to the approval of the General Assembly. Para 11. The Secretary General of the UN shall provide the necessary staff and facilities for the effective performance of the functions of the committee under the present convention. Para 12. With the approval of the General Assembly, the members of the committee established under the present convention shall receive emoluments from the UN, resources such as terms and conditions as the Assembly may, on such terms and conditions as the Assembly may decide. Article 44. Para first, states parties undertake to submit to the committee through the Secretary General of the UN reports on the measures they have adopted, which give effect to the rights recognized herein and on the progress made on the enjoyment of those rights. A. Within 2 years of the entry into force of the convention for the state party concerned. B. Thereafter every 5 years. Para 2. Reports made under the present article shall indicate factors and difficulties, if any, affecting the degree of fulfillment of the obligations under the present convention. Reports shall also contain sufficient information to provide the committee with a comprehensive understanding of the implementation of the convention in the country concerned. Para 3. A state party which has submitted a comprehensive initial report to the committee need not in its subsequent report submitted in accordance with paragraph 1b of the present article repeat basic information previously provided. Para 4. The committee may request from states parties further information relevant to the implementation of the convention. Para 5. The committee shall submit to the General Assembly through the Economic and Social Council every 2 years a report on its activities. Para 6. States parties shall make their reports widely available to the public in their own countries. Article 45. In order to foster the effective implementation of the convention and to encourage international cooperation in the field covered by the convention. A. The specialized agencies, the UN Children's Fund, and other United Nations organs shall be entitled to be represented at the consideration of the implementation of such provisions of the present convention as fall within the scope of their mandate. The committee may invite the specialized agencies, the United Nations Children's Fund, and other competent bodies as it may consider appropriate to provide expert advice on the implementation of the convention in areas falling within the scope of their respective mandates. The committee may invite the specialized agencies, the UN Children's Fund, and other United Nations organs to submit reports on the implementation of the convention in areas falling within the scope of their activities. B. The committee shall transmit as it may consider appropriate to the specialized agencies, the UN Children's Fund, and other competent bodies any reports from states parties that contain a request or indicate a need for technical advice or assistance, along with committee's observations and suggestions, if any, on these requests or indications. C. The committee may recommend to the General Assembly to request the Secretary General to undertake on its behalf studies on specific issues relating to the rights of the child. D. The committee may make suggestions and general recommendations based on information received pursuant to Articles 44 and 45 of the present convention. Such suggestions and general recommendations shall be transmitted to any state party concerned and reported to the General Assembly together with comments, if any, from state parties. Part 3, Article 46. The present convention shall be open for signature by all states. Article 47. The present convention is subject to ratification. Instrument of ratification shall be deposited with the Secretary General of the UN. Article 48. The present convention shall remain open for accession by any state. The instrument of accession shall be deposited with the Secretary General of the UN. Article 49, para 1st. The present convention shall enter into force on the 30th day following the date of deposit with the Secretary General of the UN of the 20th instrument of ratification or accession. Para 2. For each state ratifying or acceding to the convention after the deposit of the 20th instrument of ratification or accession, the convention shall enter into force on the 30th day after the deposit by such state of its instrument of ratification or accession. Article 50, para first, any state party may propose an amendment and file it with the Secretary General of the UN. The Secretary General shall thereupon communicate the proposed amendment to the states parties with a request that they indicate whether they favor a conference of states parties for the purpose of considering and voting upon the proposals. In the event that within 4 months from the date of such communication, at least one-third of the states parties favor such conference, the Secretary General shall convene the conference under the auspices of the UN. Any amendment adopted by a majority of states parties present and voting at the conference shall be submitted to the General Assembly for approval. Para 2. Amendment adopted in accordance with paragraph 1st of this present article shall enter into force when it has been approved by the General Assembly of the UN and accepted by two-thirds majority of states parties. Para 3rd. When an amendment enters into force, it shall be binding on those states parties which have accepted it or accepted it, other states parties still being bound by the provisions of the present convention, and any earlier amendments which they have accepted. Article 51, para first, the Secretary General of the United Nations shall receive and circulate to all states the text of reservations made by states at the time of ratification or accession. Para 2, a reservation incompatible with the object and purpose of present convention shall not be permitted. Para 3, reservations may be withdrawn at any time by notification to that effect addressed to the Secretary General of the UN, who shall then inform all states. Such notification shall take effect on the date on which it is received by the Secretary General. Article 52. A state party may denounce the present convention by written notification to the Secretary General of the UN. Denunciation becomes effective 1 year after the date of receipt of the notification by the Secretary General. Article 53. The Secretary General of the UN is designated as the depository of the present convention. Article 54. The original of the present convention, of which Arabic, Chinese, English, French, Russian, and Spanish texts are equally authentic, shall be deposited with the Secretary General of the UN, in witness whereof the in witness thereof the undersigned plenipotentiaries, being duly authorized thereto by their respective governments, have signed the present convention. So this is the end of the Convention on the Rights of the Child. So please do like, share, and subscribe my channel for regular updates like this on international law. So goodbye for now. See you.